This is Michael Popok, Legal AF After Dark Time, Daylight Savings Time edition. On the last episode of Legal AF, the leading podcast at the intersection of law, politics, and justice, Ben Meiselas and me went down and dirty to talk about what is going on in the New York Attorney General case against Donald Trump. Why was Donald Trump's lawyers gagged this time as they continue their merciless attacks on the judge's law clerk of all things? How did Don Jr. and Eric Trump do? And what is going on in anticipation of Ivanka and Donald Trump actually taking the stand? And how is the case going so far for Donald Trump after the completion of week 5? Thumbs up or thumbs down? Tune in now for a clip, Ben and me. What we're watching is judges struggling to get Donald Trump under control. And we're watching it in various courthouses around the country. Sometimes it leads to immediate appellate involvement at the appeals level. Sometimes it doesn't. But in the same week, almost the same day, we see multiple judges trying to get Donald Trump to participate appropriately in the criminal justice system and not use extrajudicial, meaning outside in the street, carnival-like violent rhetoric to undermine the judicial process. So you've got a judge in the federal court in a civil case who ruled yesterday, almost the exact same time that Donald Trump's lawyers were being gagged, again, that there would be an anonymous jury because Donald Trump is prone to violent rhetoric and attacking them, and they need protection. At the same time that in the same week that another federal judge reimposed her gag, while an appellate court is struggling with whether that gag should be reimposed at all. But all we're watching, whether it's Judge Chutkan, Judge Kaplan up in New York, Judge McAfee, who already decided to have an anonymous jury for their protection when Donald Trump is is being tried, and the others, and these gag orders, is a justice system, state and federal, struggling to control and out of control Donald Trump.
It's such a great point that you make. It's like the systems that we have in place that were the envy of the world. They modeled systems in democracies, that is, after our system. How are you able here in the United States? You know, the pro-democracy loving international community would always want to ask and learn to rely on these norms, right? Rely on traditions, rely on precedent. And, you know, one of the things that you think about as a young law student too, which is so interesting, is so everyone, this tapestry that is the American jurisprudence is actually held together by the kind of full faith and credit just of the system, of the belief that it works. And it could be ripped apart
by people, contract.
By people who undermine it. And it's such a great point that you make. And so you see when this system that has worked, definitely not perfectly, but has been the envy of the world, when that kind of comes into touch with Donald Trump, somebody who attacks NATO, someone who praises Vladimir Putin, it would be the equivalent of if you brought like a Putin into this system. How would they react? If you brought a Viktor Orban or a Kim Jong-un style malignant narcissist, sociopathic authoritarian, they would behave the same way. And that should be so anathema to our great constitutional system here that's built upon rules and order and professionalism. And then you even see, Popok, and we should just get into it right away. I'll toss to you on this New York Attorney General civil fraud case with the gag order being imposed on Donald Trump's lawyers. Even people like a Christopher Kise, for example, somebody who prior to this actually had a good reputation. He was a solicitor general in Florida, known as being a respected lawyer, even if it made you upset or whatever that he was representing Donald Trump. I used to say here, look, he's known as being a good lawyer. But when you watch someone like Christopher Kise play with pigs in the mud and then himself just get dirty and gross, like he spends his days right now attacking the judge's law clerk. And he says he's getting angry that the judge's law clerk is passing notes to the judge, which, by the way, is her job to help inform the judge. And that's what he talks about. And he goes there. We have two adversaries. They're obsessed with the law clerk. And as Judge Engoron said to Kais, like, this sounds misogynistic and just weird. Like, what are you doing? And Engoron had to issue an order. Maybe we start with that, Popok, because as a lawyer, watching just the behavior of those lawyers, that's out of control.
And I have a unique perspective too, because I practice in Florida, where Chris Kais practices, and I practiced in New York for 32 years. I'm embarrassed for Chris Kais. I really am. And I think he's very close, as I said on a recent hot take, to having his license, his permission slip to practice in New York on this case pulled by the judge, because he is practicing law in New York on a permission slip. It's called a pro hoc vice admission. We all do it. I'm pro hoc vice in numerous jurisdictions right at this moment around the country. But that is a license. That is a permission slip that is granted by that court. And it assumes that you will know and understand and learn the rules of the court, the chamber, the courthouse, the appellate rules, as if you were a New York lawyer. And to watch Chris Kais and Alina Habba, I'm not letting her off the hook, even Cliff Roberts, the other lawyer that's there, is an embarrassment. I thought I was watching a long lost sequel to My Cousin Vinny, where the judge has to teach the lawyer the fundamentals of the courtroom. Let me break it down, Chris, and I've done this for him in a hot take about the difference between Florida practice, where he's applied his trade, and Florida appellate practice, and the rough and tumble world of the New York Supreme Court, where I regularly practice. There's a big difference, and Chris doesn't want to acknowledge it because it's not to his benefit to acknowledge it. So instead, as I said, he comes in like some sort of My Cousin Vinny, like, oh, you were serious about that? Yeah, we're serious about that. In Florida, there is no law, there is no equivalent to the principal law clerk. In New York, the principal law clerk is an attorney. The principal law clerk for Judge Engoron, for example, was a trial attorney, a trial lawyer for the Corporation Council of New York, which is it's the city of New York's law department. I know about it. I've hired people from it. I have a current associate who's from the Corp Council. They are very well trained. It's an elite group. She was a trial lawyer there. She's not just a clerk, like just finished law school or is in her second year of law school. In Florida, there is no real clerk. Occasionally, a judge will get a clerk for the summer, but the person that is their administrator is the judicial assistant. We call them the JA. The JA is really there to help you get in to see the judge, submit papers to the judge, get a hearing with the judge, get a piece of paper to the judge, get an order out of the judge, like that. That's the JA. You know, I always taught my legal assistants to become friends with the JA because they can make or break your life in terms of if they like you, they get you on the docket. And if they don't, they don't. There's no equivalent for that. So I understand, but he now operates in New York. And the principal law clerk who's assisting a judge on a bench trial that's responsible for being the sole trier of fact is not only permitted to communicate with the judge frequently during the trial about things that she observes or he observes that assist the trier of fact. For instance, and if there was technology involved, if Judge Engoron was a computer person, she would be doing it with direct messaging or computers. But because he's a little bit more old school, this principal law clerk physically passes him notes when she sits next to him. Totally appropriate, but it's just giving Chris Kais a visual that he could latch onto. So here's examples of where I am sure the law clerk is passing notes to the judge. There's now been over a dozen witness testimonies. There's now been over thousands of pages of evidence, hundreds of exhibits. If she remembers that when Don Jr. is saying something that's completely inconsistent with a document that she's aware of that's an evidence or a testimony from somebody else, like Don Bender, the Mazers accountant or something like that, I am sure she is writing, Don Bender at Mazers said the following and handing it to the judge. Or that's inconsistent with 2018 statement of financial condition and handing it to the judge, because he alone, not a computer, one man, one person has to make the decision after listening to 5 months of evidence, One of her jobs is to keep track of the evidence and the narrative that's in the room and pass it along to the judge. So everything that she's doing is appropriate. And the fact that in her prior life, she may or may not have donated to Democratic causes, and I'm not even sure that's true, is completely irrelevant to her ability to do her job as a trained attorney, member of the New York Bar, and a person who's taken an oath to be the principal law clerk for a judge. And the fact that he cited, I know you just put something up on a hot take that I loved, he actually had the balls, Chris Keiss, to cite Breitbart as the source of some evidence about the political donations of the law clerk, which is completely inappropriate. There were groans in the room when he cited Breitbart as his source that came from the audience, like head slaps. Are you kidding me? And the judge and both the New York Attorney General that was handling the case that day and the judge said, "You think you got grounds to recuse me or disqualify me or something? Bring it. Bring it. You have more than enough of things that you would like to bring up. Bring it." It's a very New York moment. It's almost like Robert De Niro and Taxi Driver. You talking to me? Bring it. File the motion, Chris. But you're going to stop attacking our process, our system, our rules, and this particular principal law clerk who happens to be a woman. And it's starting to look a lot like misogyny on your part. So that's how the second gag order came out. And they can go take them up on appeal and use it as grounds. I'll go out on a limb and make a prediction. They are not going to get Judge Engoron off this case through the First Department, who's watching this case closely, all those judges, whoever's going to be assigned to it, and don't like the way their law clerk, their system, or their judge are being disrespected on a daily basis as part of the strategy of Donald Trump. In terms of the testimony, I'll leave it on this. I'll turn it back to you. The fundamental problem with the brothers, Eric and Don Jr., and I don't care how old they were at any given moment. Sure, Eric Jr. was 26 during some of these issues. That's not my problem. Donald Trump put his crash test dummy sons and daughter in roles that they were not prepared for, didn't have any interest, desire, or skill to hold. And that already violates New York law. New York corporation law says, as most states, that people that are officers and directors have an obligation to perform their duties with care and with the care that a reasonable, prudent person in a similar position would exercise. So for them to keep saying, I just relied on all the accountants and the lawyers. Yes, there is a body of law that says that if in exercising your reasonable care, you're allowed to rely on experts that give you information. But that doesn't work when the experts have already testified, like Don Bender at Meiselas, that they relied on the information about appraisal value from the Trump organization. The arrow went the other way. So you can't say, well, I relied on Meiselas numbers. Well, Meiselas said they relied on the Trump organization numbers. And you signed all of these forms before they were sent into banks for lending. So the Don Jr. and Eric defense, for me, actually proves the fraud. Part of the fraud for me, and I'm sure for the judge, is that Donald Trump purposely put people that were ill-suited, not prepared, into these positions of control within his company. Chief financial officer, whatever Don Jr. was, whatever Eric was, whatever Ivanka was, he put them in there on purpose so that he had no controls for what Donald Trump wanted to do. Nobody would stop him to commit his fraud. And that's all we're watching. We're just watching the feckless children who were in inappropriately placed positions purposely by Donald Trump in order to execute his fraud.
The rinse and repeat part of Don Jr.'s testimony referred to the fact when the New York Attorney General lawyer showed that for 2017, 2018, 2019, 2020, all of the years where Don Jr. stated, and the years before that, mind you, where Don Jr. stated that he's never even seen the statement of financial conditions, he was signing his name and executing certifications that those statement of financial conditions were true and accurate. So when Don Jr. laughed and said, rinse and repeat, he was referring to, like, let me give you some legal advice, Don Jr. It's too late because you already testified. So it's not like this could help you for those saying, don't give Don Jr. legal advice. You don't say rinse and repeat in a case involving systemic and persistent fraud, where rinse and repeat refers to your scam of rinsing and repeating the fraud over and over again. Like, I don't know if it gets much more damaging
Rob
than
the
that.
bank, rinse and repeat.
Rinse
Rob
and
the
repeat.
bank.
I go to the next branch. Rinse and repeat. You go to that branch. Rinse and repeat. And then Eric tried to basically pull the same thing, right? Eric said, yeah, I'm just the guy who pours the concrete here. I don't get involved in statement of financial conditions. And then the New York Attorney General lawyer would show him the fact that he's on emails from Jeff McConney, the former controller, or Patrick Burney, or this person or that person, or that he was having communications with the lawyers and the tax appraisers and all these things, that he was involved in it. And Eric would have to then say things, well, like, I don't really, I'm not the one who really gets involved in that. I rely on the professionals and they tell me what to do. But ultimately, you're the fiduciary, you're the leader. The buck stops with you. And to all the MAGA splainers out there who want to say, you don't know how it is, Ben, this is how businessmen do it. It's not.
No.
It really isn't. It's not how business people do things. Stop the MAGA splaining.
I've worked inside of a corporation larger than the Trump organization. I know what these different control officers are obligated to do. The owner of my company and his children were all involved, and everybody was involved with the statement of financial conditions. So that's how business works in New York, having worked in business in New York.
And there's no such thing as you give the task to a outside professional who you hire, and then you just close your eyes and you don't review it. That's not a thing that successful business people or any business people do. And in the course of my representation of a lot of successful business people and small business people, and all, people look over what their statements are before they sign something that could make them otherwise liable for the representations that they are making. So that was Eric's testimony. That was Don Jr.'s testimony. And by the way, the one thing I want to mention too, the Trump organization is actually not an overly complex organization. When I asked Michael Cohen, he's like, maybe there's like 10 to 12 like executives, maybe. And yeah, sure, there are like a lot of, employees and catering or this and that. But like in terms of like the core group, this is not like, let's say, Cushman and Wakefield, which Eric Trump claimed that like he didn't even know what Cushman and Wakefield was. Like, if you're in real estate, you know what Cushman and Wakefield is, which is actually a multinational corporation that actually brings in revenue of more than $10 billion a year. I think that's what their 2022 was. And Eric's like, Cushman and Wakefield? Cushman? What's this Cushman and Wakefield thing? Cushman and Wakefield actually has a lot of executives. The Trump organization doesn't. They all know each other. It's mostly run, by Donald Trump saying whatever he wants to do. The complexity within the Trump organization is actually keeping the lies straight with all of the kind of fraudulent representations. The fraud is, how do you play the refi game, and how do you manipulate the assets in a way that tries to get around everything so that you can avoid paying taxes, you can take out loans, and you can use the money you take out to try to buy more assets, and then basically run the same scam again, and then basically claim a premium because you claim that it's your part of the brand premium, which by the way was in there, or there was a presidential premium, which is what a lot of people testified to as well, is that if he would take an asset for $10 million, he would then basically, through the brute force, similar to what he does to try to tell Americans that the election was stolen. Just think about his approach there. He does that same game of lies with finance. And so he basically runs bully over the banks and over all of them too, and basically says to them, look, this is just like he goes, the election's stolen, same thing. This is a $200 million asset right now. That's actually a $10 million asset. And by the way, he'd get away with it, but for this fact, that he then makes the conflicting representations to the different entities to gain different benefits. And that's where he gets caught. He'd get away with it if he just inflated high and then inflated high to everybody. He'd actually get away with it, even though it would still, in my opinion, be very problematic conduct. Where he catches himself in his own fraud is he tells the appraiser it's this, the insurance company this, and the taxing and the lender this. One more point, and I'll throw it back to you. Yeah. The moment where Chris Keiss, there were the audible gasp, and you heard it where Judge Engoron was just like, "I'm absolutely issuing this gag order," is when they cited this like conspiracy riddled account called Judicial Protest. And this is an account that's actually been the subject of other federal court orders in other federal in federal cases that have basically stated that the statements made by this account are kind of erroneous and false, and like the Breitbart article relied on like a right-wing radical account that has been adjudicated before, that a federal court has said has made misrepresentation. So it's like double, triple layers of hearsay coming from like the kind of 4chan-ish community, and that's what Christopher Keiss has become. So Engoron's like, gag order now imposed on you. You've made your record. Stop talking about my law.
What's your source? Oh, something called the 69th Amendment, some dirty address on Breitbart. The thing that you raised during the midweek is also important. I want to re-raise it here, which is all of this testimony by Don Jr. And Eric doesn't solve for the equation, or for the equation of the defense, which is why were the numbers cooked on the books related to the appraised value of properties emanating from the Trump organization? Who did it? Why was it done? And the like. They just said, wasn't me, piece of paper, point the buck, pass the buck, a lawyer, an accountant. I don't really know what that means. Rinse and repeat. That doesn't answer the question that is at the heart of the case. The books were cooked. Why were they cooked, and who cooked them? They can keep fighting over, well, appraisal is it's an art. It's not a science. There's no real number. It's whatever I think when I wake up in the morning. Forget all that. The judge has already decided in his original summary judgment that that's not true, that there is something called a scientific approach to appraised value, and that properties have a value, and they don't change in dramatic fashion over time, year over year, just because you want to try to move up in the Forbes 400 list of wealthiest people. And then, as you said, Ben, and you demonstrate that you know you're participating in a fraud, because then you shrink the size of the asset, you deflate the asset when you want to get a tax break or an insurance break or the like. And so there's these two kids, these two adults, one's 46 years old and one's 39 years old, they don't have the answer to that question. They keep saying it was somebody else, but the problem is that somebody else is the Trump organization, because the outside accountant, Meiselas, has said the numbers came from inside. It's like that old horror movie, The Caller is in the house. The caller is in the house. It's like Scream, except financial version. So we've got no witness so far who has taken the stand on behalf of the Trump organization that you would think would be favorable to them, has solved for the problem of their defense. And that is a major problem. At the rate they're going, as I said at the midweek, Engoron has 2/3 of his decision and order already written. He's just waiting for the next 2 months of testimony to come in. Yes, Ivanka will be fun. And I want to see who they pick to cross-examine Ivanka. And Donald Trump, of course, is going to be just show-stopping in terms of how he performs on the stand, and how they're ready to vivisect him, in front of Judge Engoron. But he is ready to rule. It would be almost impossible for the judge, having found on summary judgment that there was what I'll call unintentional, persistent fraud, to then, after listening to the evidence so far, to not conclude that the other 6 counts of fraud haven't been satisfied by the New York Attorney General, to allow him to do all of those remedies that are, which you and I talk about as a perverse monopoly game, where he's going to lose his buildings, his houses, and his money because the Attorney General is going to get it for him. And the interesting thing that came out of recent reporting, and I did a hot take on this, is every time you and I talked about the complaint that she filed, that the New York Attorney General filed, we would always do like this little side voice, this sotto voce thing, where he would say, well, count 1, and that's also a crime in the state of New York. And count 2, that's also a crime. And count 6, that's also a crime. And some people were saying, well, why isn't this a criminal case then? And now there's reporting that there had been serious discussions about not bringing this as a 63-12 case under the executive law of New York as a civil fraud case, but to go to the governor and get the governor to give permission under 63-3 and let this be a criminal case for enterprise fraud, enterprise corruption, or RICO, or like a racketeering case brought by the New York Attorney General, not by a local prosecutor, against them. Apparently that got rejected. The reporting by one of the news media outlets was that Cuomo didn't want that to happen when he was governor. And so it spun off into these subparts. That's why the Manhattan DA went after the Trump Organization for tax evasion only, and also Stormy Daniels. And that's why there's a civil fraud case. But it could have all been brought under the rubric of a criminal case to put Donald Trump in jail had somebody had the balls to do it.
2 points I want to make. Number one, to that point, the Manhattan District Attorney's Office is still watching intently what is going on in this New York Attorney General civil fraud case. So when Eric was being cross-examined and he was given the severance agreement that he says that he was involved in with Alan Weisselberg, which said that Alan Weisselberg would not be cooperative with adverse parties. And the New York Attorney General lawyer said, so would you consider us to be an adverse party? And Eric walked right into it and said, yep, I would consider you to be an adverse party. Let me tell you what the correct answer was. The correct answer would be that Alan Weisselberg would still be required to provide the lawful testimony anywhere. We couldn't predict all of the potential adverse parties if a lawyer was speaking with Eric Trump. But Eric Trump was really jolly right there to walk right into it and basically say, yep, that's what it is, because they're trying to act like, New York Attorney, trying to be like his dad, New York Attorney General Letitia James, this and that. So what the New York Attorney General lawyer there was basically creating was a record where Eric can't invoke the Fifth, where that's going to be turned over to the Manhattan District Attorney to evaluate and assess if that is obstruction of justice or obstruction generally, and if that is criminal. And there are some other things that definitely the Manhattan District Attorney is going to want. Number two, you mentioned a great point as well, Popok, and it really just comes down to evidence that the Trump Organization, is their defense is not me, this person, that person, but they're not disputing really the evidence that the books were cooked. They're just blaming each other for it. And so when we talk about the summary judgment order that was handed down by Judge Engoron, it was based on undisputed evidence because the Trumps didn't put evidence. Eric's not arguing on the stand. There wasn't a direct exam where Eric's like, no. You've got this all wrong, New York AG. These values were accurate. Here's what we did. We brought in the appraiser. The appraiser told us this, and that's why we did it. We made sure that we were accurate. I do my due diligence on everything. That's what an innocent person would say. No, we hired this company. I sat there with the professionals. We took 12, 15 meetings. I can't even remember how many hours we spent. We went through the spreadsheets, and we were confident this is the right number. So no, New York Attorney General, your expert's wrong. We have our own experts because we went through this, and they don't do that at the Trump Organization.
No battle of experts here.
Exactly. And then even when it comes to Ivanka's testimony, one of the things that Engoron pointed out is that Ivanka's lawyer never even submitted an affidavit for Ivanka to make any of the points that what she was trying to make when she tried to claim she's a Florida resident and she's too busy and all of these things. And Goron's like, it is Hornbook law. It is law 101. You submit an affidavit with your moving papers.
Right.
You don't at a hearing say, you know what, maybe I'll get you one. He goes, it's too late for that. And that's, to me, Popok, I know for you, as lawyers, these are the most basic procedural moves that you do, that the Trump lawyers and the Trumps, they don't bring evidence, they don't follow the rules, and then they go out there, and Eric does the stupid accordion hands now too, and they do the dumb freaking accordion hands thing, and it's like, and I'm sitting there and I'm like, just follow the rules, just go through it, bring in the evidence. And by the way, if they brought in good evidence, I would be the first person here to talk about, hey, wow, that was a damaging day, man. Eric was actually good. He brought in some spreadsheets.
They didn't just change the numbers to make their daddy happy. And the thing that proves your point the best, and I know we'll talk about this as part of the whole episode, is what he did outside in front of the cameras. That's a whole different Eric Trump, but still said the exact same thing, which is they don't have any proof or evidence to defeat the fundamentals of the Attorney General's case about the fraud scheme that was used, and the multiple components of the fraud scheme used by their father. Instead, all he's left with saying to the bank of cameras outside is, we took out the money. We repaid the money. We were never late with the payments on the money. And this is a big taxpayer charade. Election interference 2024, and walk away. That's all he's got, because his performance in the courtroom is one of the things the judge is going to cite, his testimony, along with Don Jr. and the future of Ivanka, to support the fact that there was no credible counter evidence. The standard here, just to remind everybody, is not a criminal case standard. Letitia James's team does not have to prove their case of persistent intentional fraud that's left in the 6 counts to get the remedies they're seeking beyond a reasonable doubt. In front, hopefully one juror will have reasonable doubt. Forget that. This is a bench trial with a judge, and the standard is preponderance of the evidence. Just ever so slightly more evidence on their side than on the other. Well, that's easy. There's no evidence on the other side. There's an occasional gotcha moment with a cross-examination question. 9 hours of Don Bender, the lawyer for Mazars, testifying, shitting all over the Trump organization and Donald Trump particularly. They get like one cross-examination. Just, do you remember this email? There may be perjury. You should get your own lawyer. I mean, put away all that bullshit, all that histrionics. I don't know why I'm cursing so much today. It must be the cold medicine. It's the cold medicine. I don't know. But there's, other than that, which gets over-reported in the media, not on shows like ours where we're really diving into it, but in other shows, there's no pushback. There is nothing on the other side of the scale right now for the judge to consider. Now, I know we're in the case in chief for the New York Attorney General, and we haven't yet turned, so we're waiting with bated breath. But we've seen many of their same witnesses already in the case in chief being called in as hostile witnesses. So it's not like they can change their testimony when they get over there. And there's not, it's obvious, Ben. It's obvious, to your point. There's not going to be evidence that they didn't cook the books. It's just going to have to come down to the judge believing that Donald Trump can make up whatever number he wants at whatever moment that he wants. But then what do you do about the deflation part, which is your point about trapping yourself in your own fraud? That's the problem.
And that's where Donald Trump set the trap for himself and fell into his own trap. And fortunately, that's a kind of something that we refer to as MAGA. It has that kind of, idiocracy element. They push it because the greed is just
cheap,
impossible.
Right? He is cheap.
They just push it that one extra level that fortunately exposes it all, and we will keep exposing it all here on Legal AF.
All right, that's an example of what we do twice a week on the MeidasTouch Network exclusively on Legal AF. on Wednesday nights at 8 p.m. and Saturday nights at the exact same time. We take those videos, we put them on audio platforms wherever you get your podcast from. If you know Legal AF, welcome back. If you don't know us and you only know other content on the MeidasTouch Network, or you just stumbled in here, we do that times about 5. In other words, we got 5 stories at the intersection of law, politics, and justice. We curate them for you, and then we use, as leaders of Legal AF, our collective 75 years of legal experience. No, I'm not that old. We just added it up between Karen Friedman-Agnifilo, former prosecutor, me, 30-year defense lawyer, and Ben Meiselas, civil rights lawyer and co-founder of the MeidasTouch Network itself. So tune in, give us a thumbs up. See you on the next episode of Legal AF right here on the MeidasTouch Network. Until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.